Namaste Atman, Pranam, Vande Mataram. General insurers, especially the four public sector general insurance companies, are in a rundown condition, mainly due to motor third party liability, amongst others. May I talk a little about motor third party insurance? Number one, it is compulsory. Number two, if a motor vehicle causes any accident and the victim is awarded any compensation by a competent court of law, the insurer is liable to satisfy that award, and the insurer's liability is limitless. Now, courts are passing crores of rupees awards, and some insurance companies are on the verge of collapse. Now, here, may I point out one very important thing? Are you aware that as per section 149 subsection 1 of the Motor Vehicle Act, the insurer is not liable to pay any sum exceeding the sum insured? Well, let us read what is there under section 149 of Motor Vehicle Act. I'll read the bold portions. It will be more conceivable then. If after a certificate of insurance has been issued and a judgment or award in respect of any such liability is obtained, then the insurer shall pay to the person entitled to the benefit of the decree any sum not exceeding the sum assured payable thereunder. Payable thereunder means payable under the policy. A perusal of section 149(1) of Motor Vehicle Act makes it amply clear that the insurer's liability is nothing more than the sum insured payable under the policy. Law is clear on the point. But if there is no sum insured, and actually that is the position, sum insured for third party liability is not mentioned in the motor insurance policies. The word any of any sum stands duly quantified under section 149(1) as not exceeding the sum insured. But in absence of sum insured in the policy, any sum is being interpreted as unlimited by honorable courts, and while giving awards, the courts are adopting a populist approach, whereas the insurance companies are crying that they are bleeding. Now friends, if insurance companies don't want to take protection of the provisions of law, who can help? And that is not all. There is further. Year before last, Motor Vehicle Act was amended and a new subsection 2 was inserted under section 147. What does it say? It says that the central government shall prescribe a base premium and the liability of an insurer in relation to such premium in consultation with insurance IRDA. Now the base premium for motor third party coverage and the amount of liability against that base premium is supposed to be arrived at by the Government of India in consultation with the IRDA. It will put a cap on motor third party liability, of course, with prospective effect. Whereas public sector general insurance companies, they are getting crushed under unlimited and uncertain TP liability. Many are on the verge of collapse. It's a boiling problem, and the legal provision is also available. Now, dying patients, they need this oxygen which is available. Instead of a positive action, the attitude of helmsmen indicate that demolition is underway. Now, exceptions apart, top executives rarely open up. Actually, they can't compromise any fortunate position after their retirement. Second and third line top management executives, with few months or a year or two to go, they just want to pass their time peacefully. They shift the balls to some other squad than taking decisions themselves. Exceptions are always there. Otherwise, companies would not have run. But exceptions are exceptions. Can we depend on such handful exceptions? Lateral entries through UPSC are needed at top levels in all such PSUs as well. There is no dearth of efficiency in the young workforce. The steps need to be taken to retain such young dynamic officers. Have I been able to provide any food for thought? If you are convinced, you may share this food for thought with like-minded people and create public awareness. So thank you very much for bearing with me. ईश्वर हम सब की रक्षा करें. नमस्ते.